In the name of Allah, most gracious, most merciful, all praise and thanks are due to Allah, and peace and blessings be upon His Messenger. Assalamu alaikum wa rahmatullahi wa barakatuh. The Islamic law of inheritance recognizes man as a trustee of the wealth he owns for the duration of his wealth. When his term of life expires, his trusteeship over his wealth and property expires. It has then to be distributed according to the directives of Almighty Allah. Muslims who are living in countries where the Islamic law of inheritance is not applied are in a dilemma because their wealth will most likely not be distributed according to the Islamic law. From here it becomes important that they may make a will in which they should stipulate that their wealth is to be distributed according to the Islamic laws. Islam has special laws of inheritance. The Quran and Sunnah have specified the relatives who may inherit and who also specify their shares in the inheritance. A person is free to give whomsoever he or she wills during his or her life, but after death everything has to be distributed according to the laws of Allah. A Muslim in his or her lifetime, if wants to give something to his or her children, it must be of equal value, regardless of gender. One may consult books on Islamic laws of inheritance to learn more details, but basic principles are outlined here. A Muslim's wealth should be distributed among his or her heirs according to the laws of Allah. It is obligatory on every Muslim to follow the laws of inheritance, unless the heirs themselves by their own choice give up their rights in the inheritance. Allah has mentioned the rules of inheritance in several places in the Quran. All outstanding loans, taxes, unpaid zakah, unpaid mahr, unless the wife forgives it, should be paid before the distribution of the wealth. The will of the deceased should be followed very strictly, unless it is against the laws of Allah. A person has a right to donate up to 1/3 of his or her wealth to someone or some institution according to his or her choice. The rest of the inheritance must be distributed according to the rules of the Sharia. Only a Muslim can inherit a Muslim. Non-Muslim relatives cannot inherit from Muslim, nor Muslims can inherit from their non-Muslim relatives. If a Muslim has a non-Muslim spouse or some other relative, and he wants to give something to that person, then he must make a special will for that person, and it should not be more than 1/3 of his or her wealth. If a non-Muslim relative writes a Muslim's name among his or her heirs and leaves something for a Muslim may take it as a gift, but should not claim it as a right in inheritance. Only legitimate children can inherit from a person. Illegitimate or adopted children cannot inherit. A murderer or a person who was accessory to the murder of a person cannot be a beneficiary of a person whom he or she murdered. Among the surviving relatives, spouses, parents, and children always inherit. If any of them is predeceased, then other relatives receive their shares, but the rule is that the near relatives exclude those who are a step distant from them in their relation to the deceased. All shares must be according to the designated and specified percentage. It is very important that Muslims in America and the West in general prepare their wills before their death. The reason is that in America and the Western country, the Islamic laws of inheritance are not recognized. If a Muslim dies without having made a will, then his or her wealth most probably will be distributed according to the laws of that country where she or he lived, and not according to Allah's law. A Muslim in this case may be held responsible on the Day of Judgment because of his or her negligence in a very important matter. There are other disadvantages in not writing a will. The government of that country may impose some taxes that one may be able to avoid by writing a will. Also, if the deceased leaves minor children, the court may appoint a non-Muslim as a guardian of his or her Muslim children. In case a Muslim dies without any relatives, his or her wealth may not go to Islamic causes, but may go to the state and non-Islamic institutions. To avoid all these things, it is necessary that we Muslims living in any non-Muslim country where the Islamic laws of inheritance are not recognized have our wills prepared. Those who have some substantial assets should consult an attorney to make their will properly legal in the country or state of their residence, or make a living trust instead of will. A living trust has many benefits. Finally, I ask my brothers and sisters to please fear Allah and make your will only according to the Quran and the Sunnah, and not using your own reasoning. Assalamu alaikum wa rahmatullahi wa barakatuh.